So my name is Chris Pelche, and Communications Officer for the First Nations Family Advocate Office. With us is Grand Chief Arlen Dumas of the Assembly of Manitoba Chief, Karen Batson, as well as Councillor Sophie Lockhart. So I will just turn it over to them, and we shall begin.
That's it. Good morning. I'm Grand Chief Arlen Dumas of the Assembly of Manitoba Chiefs. I want to thank everyone for making themselves available, especially under these circumstances. Considering that Winnipeg and the whole world is transfixed with the COVID-19 crisis, it is very unfortunate that the province of Manitoba is using this time to pass Bill 34. As you know, starting from 2005, the Manitoba government under the NDP collected Child Special Allowance funds from the First Nations children in care who lived off reserve. This was money that was originally intended to help children in care with any extracurricular activities such as sports or music, or setting it aside for a trust fund to help these children when they age out of care. From 2005 to 2019, First Nations children have had $250 to $300 million taken away from them by Manitoba, in which they would use that money to spend on what seems like anything but the well-being of the children in care. In 2018, a class action lawsuit was filed on behalf of First Nations children who had their money stolen from them by Manitoba, in which the trial is to start in September of 2020. Bill 34 effectively removes the right to sue the province of Manitoba for their illegal action regarding their clawbacks on Child Special Allowance from First Nations children in care. Essentially, the new Manitoba law will eliminate any potential liability to these children, both retroactively and in the future. Even if Manitoba's conduct was found to be illegal by a court of law. This means that the CSA clawbacks started 15 years ago would be considered legal, and no child can file a lawsuit if the government claims possession of the Child Special Allowance funds. This is an attempt to bypass the courts and provides justification for their actions of stealing CSA from First Nations children. We respectfully disagree with Minister Stephenson's view that the Manitoba's new funding model of block funding has fixed the situation. Because of block funding, CFS agencies are starting the fiscal year running a deficit, which prevents them from using inventive measures that Manitoba claims block funding provides. It is not a choice that the government is also battling a lawsuit with CFS agencies about improper funding. But the real victim in this story are our children. They need justice, and they need compensation for the massive betrayal they received at the hands of the province. For the province to hide Bill 34 in an omnibus bill and try to secretly pass this bill during a pandemic is supremely underhanded and an attempt to deny these children. I strongly believe that if Manitoba was confident that they would win the class action lawsuit, then they would have not been a need to retroactively legalize the CSA clawbacks. Our children need to grow up in a world where they know people in authority are looking after their best interests and not sabotaging their future like the previous government did, or deny them justice like our current government is doing. We just learned that this government now finds itself in a position where they need to find revenue in a hurry and will be looking at cutting or canceling funding to what they deem as non-essential or various nonprofits. With this government, it seems that the burden to increase provincial coffers comes at the expense of our most vulnerable, and that is what is happening through this legislation and these funding cuts. Thank you very much.
Thank you very much, Grand Chief. We'll now hear from Chief Karen Batson
Good morning, everyone. My name is Karen Batson. I'm the Chief of Pine Creek First Nation and a member of the Assembly of First Nations, or Assembly of Manitoba Chiefs Women's Council. So this morning, I just would like to share some thoughts with you. Today, we come together to discuss matters affecting our First Nations children and families. As part of its so-called emergency plan, the provincial government is fast-tracking the second reading of Bill 34, the Implementation and Tax Statutes Amendment Act, without the knowledge or input from the people that will be most impacted by the act. Bill 34 does not have any direct relevance to public health measures relating to COVID-19. Bill 34 is an omnibus budget bill, which includes changes to the funding for child and family services. Specifically, Bill 34 justifies the practice of clawing back funding for First Nations children in care by the Government of Manitoba and immunizes the provincial government from legal actions in this regard. Children's Special Allowance is a monthly payment by the federal government to the province of Manitoba or private child welfare agencies for maintaining children in care. The CSA is supposed to be used by agencies to support the care of First Nations children through education, training, and recreational activities. There are currently 2 lawsuits against the province for its long-standing practice of taking children's special allowance from children that are in care. This practice dates back to 2005 and accounts for over $338 million. If Bill 34 becomes law, it will allow the province to justify removing funding, the CSA, from First Nations children in care, and will immunize the government from legal action. The fast tracking of Bill 34 to second reading significantly increases its chances of becoming law without any public consultation. While the government created a 30-day public comment period about government bills, including Bill 34, on March 23rd, it is ignoring its own process by fast tracking the bills in the guise of emergency measures. Manitoba Child Welfare represents the highest number of First Nations children in care in Canada. These numbers prove that disproportionately our families are being targeted and are vulnerable in society. We know that children aging out of care are trickling into poverty and the justice system. The province continues to set up our children and our families for failure. Bill 34 is just another example of the provincial government covering their tracks. Bill 34 traps First Nation children in the same situation they have been in for the last 150 years, taking away our resources our families so desperately need. This is not reconciliation. Article 31(2) of the Convention of the Rights of the Child states that parties shall respect and promote the right of the child to participate fully in cultural and artistic life, and shall encourage the provision of appropriate and equal opportunities for cultural, artistic, recreational, and leisure activity. Bill 34 is contrary to Article 31(2) of this convention. The First Nations Women's Council calls on the Government of Manitoba to stop fast-tracking legislative processes under the guise of emergency measures. Proceeding to the second reading of Bill 34 is not required for the passing of legislation relating to COVID-19. We call on the government to, at minimum, honor its commitment to a 30-day public comment period for Bill 34. Bill 34 has significant impacts on First Nations families and children. The government cannot fast-track this process without engaging with First Nations. Doing so is contrary to the Path to Reconciliation Act of Manitoba. Thank you very much.
It does not appear that there are any media on the line, and I do not know if Councillor Lockhart is going to make it back in. So I think that this might be the best time to end this, and we will go from there. So I wanted to thank you for attending, and Have a great afternoon.
All right.
Thank you.
Thank you very much.
Take
Have
care.
a good
See
day.
you, Chief.
Yeah, bye.
Bye.